Should successor trustees be notified about changes to the trust?
Keith, I'm going to hit you with a twofer here. I'm going to hit you with beneficiaries and successor trustees. So you got a mom and a dad that are still living, and they create a revocable living trust, still revocable, and they name 3 people as beneficiaries, and they name 1 successor trustee. Then they go and they make a massive change to that document and never inform any of the beneficiaries or inform the named successor trustee that they've made these massive changes, and then they die. Is there any problem with that?
There is not. No. And so on a revocable trust, especially, anytime that there's a change to it, there's no obligation on behalf of the settlors, the people who are changing it and creating it, to notify either a successor trustee or a beneficiary. And that's true even if the successor trustee and beneficiaries are their children. And so a lot of times people will say, well, I was the successor, why wasn't I notified? Well, you weren't notified because you weren't required to be notified. There's nothing in the law that requires you to be notified. Not only that, but while the trust is revocable, the attorneys for mom and dad have an obligation to keep that confidential unless mom and dad tell them otherwise. So if mom and dad say, I do want you to send this out and let everybody know, then that can happen. But otherwise, the lawyers have an obligation not to talk about it and to keep it confidential. So that's just the way that revocable trusts work.
Albertson and Davidson is here to help you fight for your inheritance. Check out aldavlaw.com for our complete library of helpful legal videos and articles from your favorite California trust and will litigation law firm, Albertson and Davidson, LLP.